Daf Yomi, Trek Sanhedrin, page 31b, top of the page. Well, the words Kala say, she could have burned it. Why did you not accept her testimony? Kivan de Itrazak Bevedina, by a Kala say, Lominan. Rav Nachman answered him, since the promissory note was ratified in court, we do not say that she is deemed credible to nullify its validity, because if she had wanted to, she could have burned it. The validity of a ratified document is not nullified without evidence. Nachman Simpon sheyesh alav edim yitkayem bechotmav en alav edim yatsa mitachat yedei shalish im yatsa achar chitum shtarot kasher alma shilim mehiman shlish mehiman. Rabbi raised an objection to the ruling of Rav Nachman from Braita. A receipt, simphon, of a repayment of a debt upon which witnesses are signified is ratified by means of its signatories. The witnesses testify that these are their signatures, and it is thereby ratified. If there are no witnesses that signed on it, but the receipt emerged from the possession of a third party serving as a trustee, or if it emerged after the signing of the documents, meaning the receipt was written on the promissory note beneath the content of the note and the witnesses' signatures, it is valid. Rava states this objection. Apparently, the testimony of a third party serving as a trustee is deemed credible, as he can testify that the receipt is valid, even if it was not signed by witnesses. Tiyufta Rav Nachman, Tiyufta. The Gemara concludes the refutation of the opinion of Rav Nachman is indeed a conclusive refutation. Kiyas Rav Dimi. Rav Yochanan. Loilab. Beviraya. Soter. When Radimi came from Israel to Babylonia, he said, the Rabbi Yochanan said, one can always bring a proof for his claim, and overturn the previous verdict until his claims are stopped up, meaning until he has no more claims, and he says, come so-and-so and so-and-so and testify on my behalf, in which case those witnesses are not allowed to testify. Hagufakasha Amart Yistatem Ta'anosav Aslan Rabbanan Hazar Amrit Kirvu Ish Ploni Iduni Aslan Rabban Shimon ben Gamliel. Gemara asks, this matter is itself is difficult. When you say until his claims were stopped up, we arrive at, meaning this represents the opinion of the rabbis who hold in the Mishnah that once a litigant stops presenting his claims, he cannot present additional claims later. And when you then say, until he says, come so-and-so and testify on my behalf, we arrive at the opinion of Rabban Shimon ben Gamliel that it is only in that case that the testimony is not accepted. Chitema Kule Rabbi Shimon ben Gamliel Perushi Kamafarish my ad shiistatem tanasav ad shiomar kirvu ploni vehiduni Amar Rabbar Bar Chana Amar Rabbi Yochanan, Kol Makom Shishana Rabbi Shimon ben Gamliel, Mishnah Seinu Halacha Kamoso, Chutz Me'erev Etzidan Uraya Achrona. And if you would say that the entire statement is in accordance with the opinion of Rabbi Shimon ben Gamliel, and Rabbi Yochanan is explaining his own statement, saying, what is the meaning of the phrase, until his claims are stopped up? Until he says, come so-and-so, and so-and-so, testify on my behalf. This is difficult. It doesn't Rabbi Bar Chana say, Rabbi Yochanan says, that anywhere that Rabban Shimon ben Gamliel taught a ruling in our Mishnah, that the halacha is in accordance with his opinion, except in the following three cases: the responsibility of the guarantor, the incident that occurred in the city of Zaydan, and the dispute with regard to evidence in the final disagreement. Evidently, the halacha is in accordance with the opinion of the rabbis in this case. Ela Giyas Rav Shmuel Bar Yehuda, Amar Rabbi Yochanan, the Olam, maybe Riva Sofer Anchis the Tanos of Yom Lo, Have Edim Omer, Ein Li Edim, Have Raya, the Omer Ein Li Raya, Avabo Edim Yesayam, Osha has this Sakia Shel Aviv, Mufgedes Biad Acher, Hareza Mevi Raya Visoser. Rather, the Gemara presents another version of Rabbi Yochanan's statement. When Rav Shmuel Bar Yehuda came from Eretz Yisrael to Babylonia, he said that Rabbi Yochanan says one can always bring a proof and overturn the previous verdict until his claims are stopped up, and the judges say to him, bring witnesses. And he says, I have no witnesses. But they say to him, bring evidence, and he says, I have no evidence. This is in accordance with the statement of the rabbis in the Mishnah. But if witnesses came from overseas, or if there was a saddlebag of his father's documents deposited by another individual, which are cases where he did not know of the evidence, he can bring this evidence and overturn the previous verdict, as there is no concern of artifice. Kiyas Ravdimi Amar Rav Yochanan Hatokav Eschaver Badin Echad Omer Nidon Kan Echad Omer Nelach L'Makom Havaad Kofen Osel V'Yelach L'Makom Havaad. When Rav Dimi came from Eretz Yisrael to Babylonia, he said that Rabbi Yochanan says, with regard to one who attacks another in judgment, he tenaciously raises legal claims against another, and one litigant says, let's go to the court here in our locale, and then the other one says, let us go to the place of the assembly, in the Sanhedrin, or another high court. The former litigant is compelled to go to the place of the assembly. Amar Lafanav Rabbi Elazar, Rabbi Mi Shadose B'Chaver Mana, Yotzivana Almana, Ela Kofen Oso Vidan Biro. Rabbi Elazar said before, my teacher, if so, must one who claims a debt of 100 dinars from another spend 100 dinars of travel and lodging expenses for the 100 dinars he wants to collect? Rather, one is compelled to appear and be judged in a court that presides in his own city. In Marnami, Amr of Safra, Rabbi Yochanan, Mishnayim Mishen Nitzatz Muvadin, Echad Omer Nidon Kan, Echad Omer Nelch Nukom Havad, Kofen Oso Vidan Beiro, V'im Hutzrach Devar L'Shol, Kosvin V'Sholchin. It was also stated that Rav Safra says, that Rabbi Yochanan says, with regard to two who are struggling in judgment, one of whom says, let us go to court here, and one of whom says, let us go to the place of the assembly, the latter litigant is compelled to appear to be judged in a court that presides in his own city. And if the local court needs to to ask a higher court about a certain matter, the judges write to the assembly, and the higher court sends its response. The im amar kesvutznu mezetam de natuni kosvin v'nosin lo. And if one litigant says to a court, write for what reason you judge me in this manner, and give it to me, as I do not trust your decision without explanation, the judges write it and give it to him. Another halakha was stated with regard to the location of the judgment, and with regard to a woman whose husband had a brother, and he died childless. She follows her brother-in-law for him to free her of the levirate bond through chalitza. The yavam does not have to go to her. Ad kama, Amar Rabbi Ami, filu mitzveri letzipori. The Gemara asks, how far does she have to go? Ami says, even from Tiberia to Tzipori. This is the halacha, even though the court in Tiberias was more prestigious than the one in Tzipori. Amar Rav Kahana, Mikra, Bekiru lo zikneiro, the lo zikneira. Rav Kahana says, what is the verse that alludes to this halacha? It is in the verse that states, then the elders of this city shall call him and speak to him, and if he stands and says, I do not wish to take her. Deuteronomy 25:8. The fact that the elders of the city and not the elders of her city, elders of his city, not of her city, are mentioned indicates that a chalitza is performed in his city, not hers. Amar Meimar Hilchos HaKofen also. Vayelech lemakom havad amar le Vashi la Meimar Amar Rabbi Elazar Kofen also v'dar be'iro hani mili heicha tika amar le love l'malve avo malve eved love leish malve. A Meimar says the halacha is that if one litigant wants to go to the place of the assembly and the other does not, the latter is compelled to go to the place of the assembly. Vashi said to Meimar, but doesn't Rabbi Elazar say that he is compelled to appear and be judged at a court that presides in his own city? Meimar answered, this statement applies in a case where the borrower said to the lender, let us go to the place of the assembly. In that case, the debtor is compelled to be judged in his city, but if the lender requests to go up to the place of the assembly, his request is accepted, as it is stated, the borrower is servant to the lender. Proverbs 22:7. Shilachu le mamar ukfa lidziv le kibar bisya shalom ukvan bavli kabal kadma yirmia achi havir alai esaderach imru lo hisiuhu v'yira panenu b'tveria. The sages sent a letter to Mar Ukva, the exilarch in Babylonia, which stated, to he who has light upon him, like Moses, who was called the son of Bithia, Shalom. The letter continued, Ukvan, the Babylonian, complained before us as follows, Yirmiyah, my brother, came past me. He did me a great evil, and therefore tell Yirmiyah, induce him to see our face in Tveria, where he will judge his case. Haguf Yakashia, Amarta Imru Lo, Alma Dainu Atun, Hasiuhu, Ira Panenu Tveria, Alma Shadrua Hacha. The Gemara asks, but this matter itself is difficult to understand. You said, tell him. Apparently, the intention was, judge him yourselves in Babylonia. But then the letter states, induce him to see our faces in Tiberia. Apparently, the intention was, send him here. Ela hachikam amrule dainuha Atun Itzayet Ivim Lo Hetziu V'Yir Panenu B'Tveria. Rather, this is what the sages were saying. Tell him, meaning judge him yourselves. If he listens to the court, he listens, and the issue is resolved. But if he does not listen, induce him to see our face in Tiberia. Rav Ashi Amar, Dine Knasos Havi, Lebavalo Lo Daini Dine Knasos, V'Had Shalchu Le Hachi, Kedei Lachlo Kavod Lomar Ukva. Rav Ashi said that is not the correct understanding of the letter. Rather, it was a case pertaining to the halacha of fines, and Babylonian the courts do not adjudicate in cases pertaining to the halacha of fines, as there are no ordained judges there. Such sages are only found in Eretz Yisrael. Consequently, it was necessary to send the case to Eretz Yisrael, and the fact that they sent the letter to Mar Ukva using this wording, as though he were capable of adjudicating the case himself, was an order to give honor to Mar Ukva, which was a sage and a leader. They hinted to him that he could not judge this case, and that he therefore had to send the defendant to Eretz Yisrael. Hadron Allah Zeborer, we shall return to you, Zeborer, God willing, and complete the third chapter of Tractate Sanhedrin.